It's my really great pleasure to introduce today's speaker, Asad Ahmed, who I think is the fourth speaker, if I'm counting correctly, in our Voting the Divine series. The Voting Divine series is an ongoing sequence of public lectures and seminars that examines theological contexts and motives of voting and deliberation in pre-modern societies, as part of the Berkeley Center for the Study of Religious Democracy and Public Theology program. We came up with this sequence, or with this idea really, that then morphed into a sequence of lectures and, as I mentioned, seminars and workshops and things of that nature, because we were thinking about and seeking to investigate the relationship between voting as a sigil marker of democracy, presumably, and democratic or participatory practices, rituals, and theologies of both monotheist and polytheist societies in, again, the pre-modern world. Our series, or the whole idea behind it, was animated by the notion that such democratic practices are, in fact, a central feature of religious life in that pre-modern world. And after 4 lectures, or 3 lectures, and the fourth coming, right? And all the various other things we've done, I think we are getting to the point that our answer is going to be, yes, they are in fact central. And then we're going to see a little bit more in detail as to how exactly it works. So Professor Ahmed's work, of course, is particularly important in this context. His lecture, not by accident, is entitled Consensus in Early Islamic Law. As you all know, Professor Ahmed is Professor of Arabic and Islamic Studies in the Department of Middle Eastern Languages and Cultures and an affiliate faculty in the Department of Philosophy here at Berkeley, where he came after having received a PhD in the Department of Near Eastern Studies at Princeton University in 2007. Much of Professor Ahmed's specialization is in early Islamic social history and pre-modern Islamic intellectual history. And here he focused particularly on disciplines such as logic, legal theory, astronomy, so disciplines that he describes as rationalists. This work is focused on the Islamic intellectual history of the so-called classic period, that would be 800 to about 1200 of the current era in the Anno Domino way of counting years, which led to 2 highly acclaimed monographs. The Religious Elite in the Early Islamic Hijaz, University of Oxford, 2011, and Avicenna's Deliverance, Logic, Oxford University Press, also in 2011. More recently, he has shifted the focus to the period of circa 1200 to 1900 of the current era, and he has also focused the geographic reach of his interests. In particular, he is now emphasizing the Indian subcontinent much more. Here, a work, Palimpsests of Themselves, Logic and Commentary in Muslim India, is forthcoming in 2020, or is it out?
2 months.
Out 2 months?
In 2 months.
In 2 months, it's going to be out. Well, fantastic. Congratulations. He's done a lot more, and I'm not going to talk about, because or else we have no time left. I just wanted to just really emphasize how very happy we are to listen to Professor Ahmed tell us more about consensus and Islamic law this afternoon. Thank you very much.
Thank you for that very, very generous introduction, Susanna. It's lovely to see colleagues and friends here in the audience. And I want to thank Duncan and Emily, Susanna, and team, Patty, and the rest for inviting me for this. It's a wonderful series. I've attended one of the lectures and the other one on Zoom, and it's been delightful. So I hope I can contribute something here. Do I keep this on? What's your choice? It's up to you.
You could do us.
All right, so I'll do this for now. It's difficult to project with this on. The paper is rather short. It's actually an outcome of a range of reflections, ideas that have been percolating in my mind for some time, quite some time, several years actually. And I'm also teaching a class on a philosophy of Islamic law, or rather an Islamic philosophy of law, for my doctoral seminar, where some of these ideas have come and gone into the discussions and have taken new shape and have been connected with other ideas and questions. So what I'm presenting here is, in one way, something that I've been thinking about for a while, but at the same time, something that's been evolving in fact, recent months. Sort of killing two birds with one stone. Partly I'm teaching that course because it allows me, with some of my very brilliant students, to think about some of these issues. And they're in the corner. It's probably going to grill me at the end of this, as they always do. So the paper is rather short. And another reason it's short, in addition to it being in the making, is that I understand that I'm in the presence of academics who have a range of interests and specializations. Some of these topics are rather technical and deeply immersed in the tradition of Islamic studies. And so I think that in presenting them, I should give it time, and I should only present as much as is necessary at this point to get a general idea across. But then, of course, if there are questions and answers, we'll elaborate. So with all of that, then let me begin. And as you notice, I've changed. This is also an indication of the evolving interest and evolving thoughts I have. It's no longer consensus in early Islamic law. I've actually, when I was thinking about writing, and as I started writing, I started shifting, I realized, to the post-classical period, which is what I have been inhabiting for the past decade now. So anyway, the principle of consensus is a basic tool. It's called ijma. It's a basic tool meant to generate and to perpetuate the law in the Islamic tradition. In its general sense, it often refers to the consensus of the entire Muslim community on a matter pertaining to praxis, not on a matter pertaining to belief. More particularly, it is confined to the remit of the consensus of the community of legal authorities on the same matter, namely in praxis. And thus, in very basic terms, the Islamic legal theoretical systems lean on the concept of consensus to confer probative force to some of the critical principles of legal derivation and to various legal effects themselves. The notion serves as a linchpin for a tradition deeply concerned with ensuring that the human access to the divine will is established on firm footing. As such, it seems to be a suitable topic to explore in the Voting in the Divine series, of which this communication is a part. Now, I've divided today's lecture into two short parts, each with slightly increasing technical complexity. In the first part of the talk, I will say a few words about how I conceive of this thing called Islamic law at this stage of my scholarly career. And this conception has been enhanced, as I was saying in my introductory comments, in this doctoral seminar. In the same part, I will also focus on how consensus functions within this conception of law that I will elaborate on. In the second part, I will turn to an example of what we call compound consensus, in an effort to demonstrate how a conception of the legal system as a set of internally consistent propositions was facilitated by this concept, namely consensus. And then I will close with some reflections on how the theory of consensus may contribute in some way to the idea of voting the divine and to a philosophy of Islamic law itself. And here in the Q&A, I will be grateful for your thoughts on how to think about consensus within the series. So a major issue, this is the first part, a major issue that specialists of Islamic law face in contemporary scholarship concerns its definition. Part of the challenge appears to emerge from a long history of the philosophy of law that has developed in Western literature. We are familiar, for example, with two poles of this theory, one arguing for some version of natural law, and the other that displays a positivist range. There's much in between the farthest limits of these poles. A very simplified version of the former theory, namely a theory of law as natural law, undergirded by an Aristotelian essentialism that posits nature as a standard. Such a theory argues that there is such a thing as a law out there that can be discovered by right reason. That which fails to correspond to the suitable application of the human capacity of a right reason is therefore not law. This approach presupposes a deontology of human acts. There is a basic universal good that is part of the rational plan. In Aquinas' hands, there is a rational plan for the whole, the entire, the cosmos, explained by him as eternal law. Natural law is part of the latter, namely it's part of the eternal law, and its discovery by right reason makes it as binding as the law of nature. So that's a few, a set of statements about natural law in a very simplified fashion. Alternatively, a positivist reading of the law would state that a law is a law because it is so ordered by a sovereign who is habitually obeyed by people and who does not obey anyone else. His command comes with a threat when it is disobeyed. This reduces the normative force of the law to the descriptive aspects of social realities. Now, this does not prove that the law is valid in itself, which is something that natural law theories can do. It only shows why a law is a law. A version of this positivist approach would reduce law to something like a set of rules, even rules of a social game, for example, that confer rights and obligations on a social group. Now, where does Islamic law fall into all of this? There are indeed statements in the literature that would suggest a natural law theory would fit the Islamic tradition. A simplified version would begin with perhaps the Mu'tazila theologians, who posit that laws are discoverable by reason and that prophets and revelations are gracious gifts, the grace from God, that will fill in the legal gaps and that motivate people to the assiduous application of reason for the discovery of this law. A similarly simplified version might argue for a positivist conception of Islamic law. This would be perhaps the Asharite view in a simplified fashion. Laws are laws, it would state, because God so determined them and assigned blame and praise, punishment and reward for them. But the complex structure of legal reasoning belies the Islamic tradition belies any real correspondence with natural or positivist law, as developed within the rich Western philosophy of law tradition. It seems to conceive of law as a divine given that is to be discovered by the exercise of legal tools and the exertion of rational methods. Right law is certainly not made by humans. That's certainly the case, the general conception of what Islamic law is. There is indeed an underlying theological base, whether the law is such and such because of a deontology of acts, or such because God so measured out the world. But this matter, namely what the underlying theological base of the law is, does not animate the discussions in Islamic legal theory beyond a few pages, usually at the beginning of these works. Rather, the divine law is a standard, correspondence with which can never be guaranteed by human effort. The legal obligation, rather, is that one engage in a praxis that is subjectively and socially opined to correspond to this divine law, following the right kind of jurisprudential exertion. The body of the law, in effect, is the set of propositions that are the consequence of such jurisprudential work. So at this point, it makes us wonder whether this is divine law in any way, or whether it's simply and merely a juristic effort and exertion. But there are two unsettling outcomes of this perception of divine law that I've just shared with you. First, that overwhelming conviction short of certainty can obligate one to praxis is to take an underdetermined law and to upgrade it to epistemological closure. Indeed, the self-conscious legal tradition recognized that even the principles upon which such upgrading turns are also underdetermined. It is precisely the task of Islamic legal theories where this upgrading effort is manifest and where consensus plays a major part as a tool. Aside from the question of such underdeterminacy, the notion that I just highlighted, namely that the large body of legal propositions that aims to discover a divine standard is authorized by subjective cogitative effort and social authorization, may suggest that the law is relative in some sense. But in what sense can a divine law be relative? Again, a theory of consensus within the tradition of legal theory tries to overcome this problem. Let me illustrate the resolution of these two issues that I've just pointed out by means of an example. And here I quote at some length, because I think it's very important to look closely at text and to hear things from the horse's mouth. I quote at some length the 13th century Maliki legal scholar Al-Qarafi from his commentary on the legal theory work of the famous 12th century theologian and jurist Fakhruddin al-Razi. And he writes the following. Let's read this closely. And my students are familiar with this. We read this in class. I say that when, as a basis of his judgment, the qualified jurist has an overwhelming belief that a form shares something with another form, he is certain that the praxis of that to which his belief leads is obligatory. Thus, the legal effect is known to him with certainty, although the belief is something that occurred on the way to this knowledge. The point that's being made here is that, of course, a legal effort would lead to overwhelming belief, but what you want to arrive at is certainty with reference to the divine law, so that you may feel that you're obligated to act, but your epistemological state is of a lower grade. It's an overwhelming belief. The expanded explanation of this claim is as follows. Divinely sanctioned legal effects are known, not merely opined, by virtue of two demonstrations of the grade of necessity. As for the first demonstration, we say that, premise number one, every divinely sanctioned judgment exists by virtue of two premises of the grade of necessity demonstration, burhan, right? This would be episteme. Number two, everything that exists by virtue of two premises of the grade of demonstration is known. Three, therefore, the conclusion, every divinely sanctioned judgment is known. Now, we only say that in the first premise, this is number one that I've highlighted, I think, in the first premise, that every divinely sanctioned legal judgment exists by virtue of two necessary demonstrated premises, because we posit a general discourse about a legal judgment and we elaborate an argument, by virtue of whose general course we become confident about all legal judgments. So we say regarding the first premise, we're still in number one, and number one needs to be proved. And the proof of it is now coming through these new premises. We say regarding the first premise that A, the jurist Malik, he's a famous jurist who established one of the main Sunni schools of law. The jurist Malik believes the obligation of forming an intention for fasting as categorical praxis by virtue of his inner epistemological state. This is so because he finds the belief in himself, as something categorical. Premise number two. So the first premise, again, let me repeat, is the second part is simply an explanation of why the premise is true. The first premise, A, which is being used to prove the other premise one, is one more time, the jurist Malik believes the obligation of forming an intention for fasting as categorical praxis by virtue of his inner epistemological state. That's the premise. This is so because he finds the belief in himself as something categorical. Premise number two, everything that is opined by Malik is a judgment from God, the exalted, as something categorical relative to Malik and relative to the one who follows him. See, therefore, the conclusion, the obligation of forming an intention for fasting is a judgment from God, the exalted, as something categorical relative to Malik and relative to the one who follows him. So just to parse this, and I'll parse it further as I read, the first part, the first premise that is proving premise number one, so item A, seems to me to be involving two modals. One is an epistemological modal and the other one is ontological. It is the statement of the sort that I believe that X is necessary. That's Malik's opinion, right? So Malik believes that it is necessary for you to practice such and such a thing, but his epistemological state is simply of a lower grade than necessity, right? He's not saying I'm confident or I'm certain that you must practice. And he arrives at this overwhelming belief on the basis of his cogitation and the application of legal methods that are available to him. And that's a problem, because to go from that epistemological state, which is of a lower grade, to claim that your practice must happen in such a way needs explanation. That's being provided, that's going to be explained in just a second, but that's premise number one. The second premise is that whatever Malik is opining, which all will also need explanation, as we'll see, whatever Malik is opining is itself a judgment from God, but it's a judgment from God relative to Malik and to those who follow him. And if you can grant those two, then you can say that Malik's opinion is binding. Consensus is going to show up in just a minute here to do the work. Okay, so now I'm sure that so far in the argument of the two initial premises, one that you see, every divinely sanctioned judgment exists by virtue of two premises of the grade of demonstration. Two, everything that exists by virtue of two premises of the grade of demonstration is known. It is the first one that you might find requiring proof, since the second is axiomatic. It's basically a syllogistic claim that two necessity premises will provide a conclusion that is necessity conclusion. So we're not going to dwell on that. That's I hope a straightforward thing. We can argue about whether it's axiomatic or inferential, but that will take us into the field of modal logic, and we can do that in the Q&A. But they don't spend much time arguing about that. And of the proof of the first premise, because that's our interest now, the proof that is being provided, again to repeat, A, the jurist Malik believes the obligation of forming an intention for fasting to be categorical practice by virtue of his inner epistemological state. This is so because he finds the belief in himself as something categorical. And B, everything that is opined by Malik is a judgment from God, the exalted, as something categorical relative to Malik and relative to the one who follows him. It is perhaps a second premise, B, that requires further comment. Because the first one, again, it doesn't take you where you want to go, but I think given that there are two modals, I can certainly say that I have an opinion that X is necessary. That in itself is not problematic. It's the heavy lifting that premise B is doing, which is leading to the conclusion that we need to investigate. Because the first one, as I said, is a claim about Malik's inner state relative to his own considered opinion, and that can be granted. So how is it that this considered opinion is a judgment from God as something categorical relative to Malik and those who follow him? So here Qarafi explains further. I hope you guys can read it. I'm a fan of long, detailed quotations, because all the work is done by somebody else. Okay, so Qarafi now explains further. He says the second premise, right? So this is premise B, namely, again, to remind you guys, just to remind you guys that everything that is opined by Malik is a judgment from God as categorical relative to him. The second premise is based on consensus, he says. Our statement that the opinion of Malik is the categorical judgment from God relative to him and to the one who follows him is by virtue of the establishment of consensus that the obligation of saying Bismillah, for example, during the recitation of ritual prayer does not attach itself to the Malikis or to Malik, and the obligation of wiping the head, the entire head, during ablutions does not attach itself to the Shafis or to a Shafi. Those are two of the founders of the four major schools of the Sunni tradition. In other words, they're saying that this upgrading is happening because of a consensus that is granting that these certain obligations relative to a Shafi and relative to Malik, even though there are different positions that they hold, are true by virtue of consensus, right? And the consensus is holding that they are obligatory for them relative to them through consensus as a judgment of God. They do not, namely Malik and Shafi, do not disobey God in abandoning these respective acts. Rather, each of them is obedient to God in doing that which his overwhelming belief dictates. This is like the case of qualified jurists who search for the direction of Mecca. If the contrary of that which occurs in the opinion of one of them occurs to another person, then he is not disobedient to God in abandoning that which occurs in the opinion of his companion who is in disagreement with him. Rather, he is disobedient to God in abandoning that which he holds as an overwhelming opinion. God has judged proper, relative to each one, the direction of Mecca to which his juristic effort leads. Similar are the acts of those who are legally responsible, meaning people of sound mind, of certain age, and so on. The same act is both permitted and forbidden in relation to two people, as in the case of carrion, which is forbidden and permitted in relation to two people, one who has a choice and one who is compelled to eat it for survival. In the Islamic tradition, you're not supposed to eat carrion, but of course, if you're in the desert, you find nothing else, it becomes permitted. With respect to the considered opinions of the legally qualified jurists, the divine law stands in analogy to the status of the legally responsible agent insofar as he is compelled or has a choice. The two different opinions are like the two different attributes of being compelled and having a choice. The totality comprises paths to God, the exalted, and our causes of eternal felicity. So the point that he's making, and I hope that is clear, is that just as in the case of two people who are in different states, the same object, the same act becomes both, for one of them forbidden and the other one permitted. So in the case of the legal jurists, it is their state that is differing, and it is relative to their state that the obligation falls upon them. So the Malikis, on the basis of the exercise of legal reason, arrive to particular conclusions that the Shafis don't. It is in view of that God considers the Maliki opinion to be obligatory with respect to practices for Malik and those who follow him, but not for the Shafis, and the other way around too. For the Shafis, he would allow certain things. And when Malik disobeys that command, or which command is basically his own opinion, which has been sanctioned by God and sanctioned by God through consensus, that this is how it is. When he disobeys it, his own opinion, then he is going to be punished, but not the Shafi in this case, because he would not be disobedient in that case. It would be the same as, for example, given the state of person who is in the desert, person who's not in the desert and can and finds carrion and properly slaughtered meat and decides to eat carrion, well, then in that case it's forbidden, but relative to the state of another person, his relative state being in the desert, then it would be permitted. So that's the analogy that's being drawn. Now that establishing the law as actionable relies on the upgrading of a probable epistemological state to the certainty of action has been deftly dealt with by my colleague Aaron Zaisaw in a classic work, The Economy of Certainty. So I'm not saying anything new here at this point. As I noted earlier, thanks to Zaisaw's investigation, the field understands that an important function of Islamic legal theory was to develop various tools for this kind of transfer, this kind of upgrading. In my recent work, I have argued that the tradition also recognized that these tools themselves, the tools of upgrading themselves, were underdetermined and were recognized as such by the tradition. And the tradition, as I point out in a relatively recent article, was concerned with working around this underdeterminacy of the principles themselves that upgrade the probabilistic status of one's epistemological state to the necessity of praxis. In other words, they're meta-theoretically concerned with shoring up the system that itself is supposed to do the heavy lifting of producing obligatory praxis out of opinion. As we noted in the case at hand, the indispensable tool here is consensus. It is by virtue of consensus that it was established that the overwhelming opinion of Malik and the Malikis is a categorical judgment of God relative to him and to those who follow him. And then the text went on to point out that the same holds for a Shafi, and those who follow him. And it would say the same about other eponymous founders, at least, of other founders, perhaps even of qualified legal jurists and their followers. Consensus is thus the linchpin in establishing the divine law as actionable. And in its manifestation and discovery, this is the only law that is known. Otherwise, it is opinion. But what conception of law is this? Is it a claim of the relative soundness of all legal schools on the basis of consensus? Is law relative? But if so, how would this notion square with a very well-established and explicit idea in the sources that God's law is given? It is a given thing. And whatever the underlying theological argument for its basis might be, and that it is only to be discovered by humans. How can everyone holding different positions on legal effects be correct, especially if those positions are contradictory? And how could this be the case if there is only one law of God out there to be discovered? And is this divine law or human law, given how it is consensus that puts it into effect? My conception of God's law in Islam is derived from examples of the sort that I just shared with you. It appears that God's law is a given standard, and that the human discovery of this law is an exercise in modeling the structure of the law. And here I want to emphasize the notion of modeling. At the end of this exercise of modeling the law, the outcomes are put into effect in the world as praxis by virtue of the authorizing agency of consensus. Several models, the Maliki, the Shafi'i, Hanafi, and so on, taken as wholes, can be granted this authority, and ultimately by consensus. There are other tools too, but consensus plays a rather important role. But if God's law is a given standard, they cannot be relative truths in any strong sense of relativism, or not, at least not in a basic simplified sense. Rather, they're truths insofar as they have explanatory force for the entire edifice of God's law. The conception reminds me of how the Islamic tradition speaks about astronomical models. And so here, just to make my point, and you'll also see how my thoughts on this matter have emerged out of cognate work done by Muslims in other fields. So here, to talk about astronomy and astronomical models, I quote the 14th century theologian Al-Iji's Mawaqif and the commentary on it by the 14th century theologian Al-Jurjani to make my point. And in this case, the italics are going to represent, because this is an embedded commentary, there's a base text and the commentary that's a running commentary with it. You can actually, if you don't have lines and italics and so on, you can even imagine that it's the work of one author. There's flow, the way it's written, there are usually no gaps and no distinctions in the voices of the two authors. So anyway, the italics represent the words of Iji, the base text, and the rest is the commentator Jurjani. And I'm going to offer a detailed quotation because I think this will help us try to figure out how Muslims are conceiving of what the law is, given this problem of consensus, which is humanly sanctioning the law. So Jurjani on Iji says the following. Okay, so these 10 great circles and others, and that which is based on them, are imagined things that have no existence in experimental reality. So he's talking about, say, the model of Ptolemy, which has 10 great circles, as you guys might know. And he's saying the claim that E.G. is making, again, is that these 10 great circles and others, and that which is based on them, namely the theories that are based on them, are imagined things and have no existence in mind-independent reality. There is no objection from the perspective of religion to things like these. They do not pertain to creed, and neither affirmation nor negation is directed towards them. So there is no need for us to mention them in this book of theology, except that we mention them in it so that you, reader, may understand their intentions in the discipline of astronomy, in the intentions of the astronomers. If you think of them as mere imaginings, the weaker than the house of a spider, listening to these words, which are merely loud sounds, will not cause you to perish. And now Jurjani explains, the loud sounds referred to here is the sound of armor and of similar things issuing from dry things. It is, as in the proverb, I will not be made to be afraid by the sound of the beating of a dry water skin, namely that these things are sounds beneath which there lies nothing. This is just talk, it's imagined things, like the sounds of armor and of other hard things. This is what he states. And now Jurjani continues as a response to his base text. One may say that there is no doubt that when an orb moves about its center without moving from its place, then inevitably one posits upon it 2 points that have no motion at all. And these are the 2 poles. And 2, between the 2 poles, or imagine a circle, a sphere, the 2 poles are not moving when the thing is moving. Between the 2 poles, right? Between the 2 points, which are the poles, one posits a great circle, which is at the ring of the middle, namely the equator. And the motion upon this center is fast. And 3, one posits 2 small parallel circles on both sides of this equator, upon which the motion is slow in relation to it in varying degrees. For that which is closer to the pole is slower than that which is closer to the equator, because obviously that which is closer to the equator is traveling a greater distance in the same time, and that which is close to the pole is covering a smaller distance, and therefore the one near the pole is faster. And there's also no doubt that when some of the spheres encompass some others, their motions should be such that, with respect to a single sphere, their equators intersect. So this is imagining the great sphere, right, that encompasses the cosmos. And of course, you can posit the Earth, whose pole is at a degree, right, relative to the large sphere. And if you take the equator of the Earth to extend and the equator of the large sphere, which is upright, to extend, obviously their equators will intersect. So for one posits between the 2 equators, 2 points that intersect and 2 points that are at extreme distances from each other. So he's talking about the points that determine the equinoxes and the solstices. That's what you posit, that's what you will get. And let me finish this off to get to the point he's making. These and things like this, even if they do not exist experimentally, meaning mind independently out there somewhere, they are still things that are imagined in a correct manner, and they correspond to that which is the case by virtue of its very given self, namely by virtue of the fact that a given moving sphere in its place and encompassing spheres with certain types of motion were posited. Once you posit that kind of a thing in your mind, even if it doesn't correspond to the way the cosmos is, it will follow that certain points will be faster than other points. It will follow that 2 points will meet at the equator and 2 will be farthest, and so on. That's only on the basis of a mental posit, but it's by virtue of the very posit itself that other things will be true, by virtue of the posit. Sound primary intelligence bears witness to this. They're not among those imagined things like the fangs of ghouls and the mountains of emerald or humans with 2 heads. By means of these things, the states of the motions with respect to fastness, slowness, and direction are ordered or understood in a manner that relates to perception and observation by instruments. By means of these things is revealed the states of the heavens and the earth, and of the finer points of wisdom and wonder that are in them, such that one who comes to know them is amazed at the greatness of his creator, and he says, "O Lord, you did not create this in vain." Oh, sorry, let's stay there. The point Al-Jurjani is making is that once certain models are mentally posited, although they may not correspond to anything that is mind independent, not correspond to the actual reality out there, certain features about them would be true by virtue of their very given posited selves as such. For example, there may be no spinning sphere in the actual heavens. But if such a sphere is posited to model the motions of the heavens, made to move at a certain velocity, made to be embedded in other spheres, then by virtue of this very posit, it would be correct that certain points on the sphere will move faster than others relative to their positions, and that certain points on the equator of one sphere will intersect with points on another embedding sphere. Thus, although we may not be able to verify that our model represents reality, it is a correct model by virtue of its very posit itself, and it may be used with actionable certainty for determining the station of the heavens. It will do the work, and you will have to, in fact, use the model if you want to get any work done, without knowing that whether it actually corresponds to what is out there. Other competing models may well produce the same results, despite differences in the particularities of the various posits that they might have. The conception of Islamic law to me appears to be somewhat similar. There is indeed something over and above the outcome of juristic reasoning that is God's law and is God's standard, just as there is a cosmos out there and a Mecca out there. The internal reasoning of the qualified jurist leads to the production of a legal system about which he has overwhelming confidence, but no certainty. It is an approximation of reality that cannot be accessed beyond his modeling, which is his appeal and use of legal reasoning. Other jurists may have similar models, just as the consistency in the models of the cosmos in astronomy produce results that are true by virtue of themselves and compel one to use them, so also the legal models are true in this fashion. And they are God's law insofar as consensus argues that it maps onto God's law relative to the qualified jurist and his followers. As such, the outcomes become obligatory praxis relative to the jurist who has modeled them. As such, these models are not relative truths in a strict and final sense. They are true by virtue of their very selves, and they are actionable with respect to God's given law. Now, in the second part, which is not very long, I wish to press this argument, this conception of Islamic law, a divine law that is actionable by virtue of consensus through a notion of consistency in modeling. I wish to press this argument further in this last part of my paper. And here again, the work of consensus in the production of multiple legal regimes within one given law of God will be significant. The Islamic legal theoretical tradition discusses a notion called compound consensus, ijma' murakkab. The technical term has more than one meaning. It's ijma' murakkab, or compound consensus, is discussed in different ways and has multiple shared meanings. But for our purposes, I wish to highlight only one of them. In a work called Ma'adan al-Usul, a commentary on the famous legal theoretical work, Usul al-Shashi, we read the following. And again, I'll give somewhat long quotations. This one I hope will both make you laugh and will make you cringe. It's entirely hypothetical, I hope. It says the following. We say that consensus is of two types. And I'm using the same rules, by the way. The italics is the base text, and the other one is the commentary. So we say that consensus is of two types, compounded of two rationes legis, and not so compounded of them. The latter is that about which there is an agreement among considered opinions without any disagreement on the ratio legis. The compound consensus is the agreement of considered opinions on the legal effect pertaining to an issue. Its example is the consensus that ritual purity, we call wudu, ritual purity, or tahara, sorry, is nullified in the case of vomiting and touching a woman, meaning one who vomits and touches a woman. For us, the Hanafis, I'm sorry, I'm smiling because this is actually a person who's vomiting and touching a woman at the same time, as you would see. So yes, entirely hypothetical situation to make a point. For us, the Hanafi, this is a Hanafi author, ritual purity is nullified by consensus due to vomiting, vomiting for us nullifies the ritual purity, and for Shafi, it does not nullify it. What nullifies it for him is the touching of a woman. But this does not nullify it for us. The argument, by the way, the Quran talks about how ritual purity passes, and it uses the expression mas, which literally would mean touching. Most traditions interpret it to mean having sexual intercourse. It's a euphemism. But one group, as you can see, takes it literally. Okay? So they actually mean literally, this is not a euphemism, just simply touching the skin is what they're talking about. Okay, next, this type of consensus is no longer probative after the emergence of the passing of one of the sources. That is to say, it's rationis leges. So if it is established that vomiting does not nullify ritual purity, then Abu Hanifa would not hold the doctrine of the nullification of ritual purity in this case. And if it is established that vomiting does not nullify it, touching does not nullify it, then a Shafi would not hold the doctrine that it nullifies ritual purity. This is because of the passing of the ratio legis on which the judgment was based. In other words, the consensus of the passing of ritual purity due to the uncertainty of the passing of the cause on both sides for both parties. So the hypothetical situation, let me spell it out for you. The hypothetical situation, which I advise you not to picture in your mind, or perhaps you want a good laugh, I don't know, but it's as follows. Let us imagine a person who vomits and touches a woman at the same time. For the Hanafis, vomiting is the cause of the dissolution of ritual purity, as a consensus held among them. But touching a woman is not such a cause, meaning literal touching. For the Shafis, the converse is the case. Yet although they, the two groups, disagree with respect to the cause, there is a consensus that this is a case of nullification of purity in the situation we have just outlined. Now, what happens if Abu Hanifa's adopted cause of the judgment is incorrect, but he is correct on the position on touching a woman? In such a case, the judgment about ritual purity would actually collapse, though it shouldn't. The case would be the same if the Shafis are incorrect about touching a woman, but correct about vomiting. What I'm saying is that if the Shafis were incorrect about their position, but correct about the other position, then the Hanafis should maintain their consensus and vice versa, but that does not happen according to law. The outcome, the author tells us, is that collapse of either cause would lead to the collapse of the judgment for either side. But why should this be so? Surely, if the Hanafis are wrong about their ratio legis, the Shafis can still be right. And if the Shafis are incorrect about their ratio legis, then the Hanafis can still be right. The text explains that the reason the consensus must collapse completely is that its starting point was a compound cause, a person vomiting and touching a woman at the same time, that produced a compound consensus between the two schools as a whole. In other words, for this strange hypothetical case, the consensus was based on a cause which was suspect as a whole. The disturbance in either part of the cause, since it is a conjoined cause, it's a conjunction, and a conjunction is false if either part is false, of course, would collapse the consensus as a whole. From a different perspective, this tells us, I'm going to first try to extract out of this situation evidence for my way of thinking about Islamic law and the role of consensus. From a different perspective, this tells us that the legal tradition imagined coherent systems of law that were valid relative to the juristic effort in question. In the case at hand, the juristic effort was joint by virtue of two joint causes. And so the collapse of one part of the compound cause led to the collapse of the consensus as a whole. Neither party can hold its position, even if the opposing party loses its particular reason for this, which reasoning would not be relative to the first party. Neither the Hanafis nor the Shafis could retain the consensus relative to themselves alone. On the other hand, as we saw in earlier cases that I discussed, had the consensus been relative to only one scholar in his school, the collapse of his system would not have meant the collapse of that of another scholar, because his system would still be a coherent whole. He would have a different model. Again, we can see that this is a case of imagining law as a model that links causes to legal effects on the basis of qualified juristic effort. The system holds together in its authority by virtue of consensus. So let me end this paper with some quick reflections. I hope to have shown to some extent in this paper that divine law in Islam is to be understood as a series of systems produced by the work of qualified jurists. The work of each such jurist is probabilistic, but the outcome is a categorical law made so on the strength of the theory of consensus specific to the legal effect. Those who follow such jurists are obligated to follow his law as much as he is, given that the consensus raises this law to the level of categorical practice. This much we already knew from the wonderful work of Zaiswal. As a next step, it is important to recognize that the multiplicity produced in this legal system does not vitiate the divine law as a given body of effects, nor does it imply the relativism that we might imagine in some strict sense. God's law cannot be known for certain, and the theological basis of such a law, be it some natural or positivist model, that becomes irrelevant. What is important is that the tradition recognizes and authorizes the validity of multiple legal systems with respect to praxis, as much as the astronomical system recognizes and authorizes the validity of mathematical models by virtue of their given selves as posits. Each system is true relative to praxis by virtue of its very given coherence. This practical truth is granted to it by the principle of consensus in the case of Islamic law. The point is rather nicely illustrated in the example of compound consensus, which I just shared, where two distinct causes support the system, each recognized by a distinct school. Yet insofar as there is a consensus of both schools on the compound system, namely the two causes taken together, not on each part that constitutes it, that's not relative, the system fails as a whole, even if one part that undergirds it collapses. Islamic law, therefore, is a series of systems of approximation, valid by virtue of themselves, sanctioned by the practice, to be practiced by the authority of consensus. It is in this sense that consensus, perhaps in some way, generates or authorizes a relevant law of God. Thank you so much.
Thank you very much. The way it's going to work is that Duncan is going to field questions from the audience that's not in the room, and either myself or you shall be fielding questions from everybody in the room. So go ahead.
Thank you very much. I wanted to ask about this analogy that you suggested, or to learn from the latter type of consensus of the compound and the prior type of consensus of the positive model. So it's a clarification question. Maybe I didn't understand, but if I did understand, then maybe you can explain. I understand that the Maliki ruling or determination is said to be divine law by means of consensus. This has to do with consensus about the authority of that jurist or that leader, that scholar. So he, as a religious person, a professional jurist, is accepted by his community as a personality, not that a specific ruling is consensually accepted with regard to the specific details of that ruling. That personality or that figure as a person that has been consensus, if there is a consensus about him, that leads to accepting his rulings, be their content as it may, as the law of God. Whereas in the latter example of the consensus that you demonstrated, we had detailed argumentation. This is how you have to interpret the Quran on the ritual impurity, etc., etc. And the consensus was in between the two opinions. So first of all, it seems to me that those are two very different types of consensus. The first one seems to come from a political acceptance of a leader. And the latter one seems to be a heuristical principle, like a procedural principle. Like like you said, you presented it logically. If we set out to rule according to consensus and we needed to require the two terms to get to the bottom line, if one of them collapses, we lose our decision. So you can explain. Thank you.
Sure, thank you. That's an excellent question. I think I can bridge the gap. So you're right. I mean, the consensus in the first case is, of course, a social and political feature of establishing Islamic law. And there are discussions about this in the case of mujtahids too, people who are qualified jurists who may exercise their reason after having developed a certain kind of habitus after years of training and so on, and having gained a certain prominence of his position in society. So their opinion, therefore, through consensus, is considered to be the legal effect or judgment of God itself in that case. But the general rule, I mean, whoever this qualified legal jurist mujtahid might be, the general rule is anyone who is such a jurist must, after determining a position or establishing a considered opinion on a particular legal matter, must still exercise it as an obligatory praxis by consensus. So the consensus applies in the same fashion when it comes to the obligation of praxis, not just to Malik, but to any mujtahid, to any qualified jurist. In the class, actually, somebody had asked, I think it was perhaps Daniel who had asked whether this would be the case for, but whether it could be another Malik. And I don't know the answer to that question, because that goes into the question whether there would be another legal school that can be established and the mechanisms that are social and so on for that. The point I was making in all of that is precisely what we're saying, is that there seems to be a human element, a social factor that is upgrading the status of Malik's opinion or the opinion of any qualified jurist, which is mere opinion or considered opinion, to the point of the obligation of praxis. That's the function it's doing there. In the second case, the point I'm making, and it's relative to establishing that we're thinking of the consensus as working with systems. In the first case, let me just backtrack a little bit. The argument is not just that it's Malik's opinion that is upgraded, but anyone who's a Maliki must also be obligated in the same fashion. So let's keep that as an undergirding, underlying position. In the second case, let me move forward. In the case of compound consensus, the idea that I'm highlighting is that the consensus is recognizing a system that is alternative to either the Hanafi system on its own or the Shafi on its own. It's a hypothetical scenario, but the point that's being made is that the joint system of the Shafis and the Hanafis with compound causes would have the same kind of obligatory status through consensus, obligatory with respect to praxis. And it would therefore also collapse together. The system would collapse. So the two ideas, I don't think you're saying this, I think the two cases of consensus are not mutually exclusive, but I was using them to demonstrate two different points. The underlying position in both cases is that consensus is recognizing some kind of a system through a social sanction. And in the first case, it's Maliki's system that's recognized as obligatory through consensus. In the second case, it's the joint system that's being recognized as obligatory as a system. That's the point I was making, but thank you. There is a distinction. I was using it in two different ways. Thank you.
I don't have a question from the Q&A yet, so I'm hoping soon. I'm wondering whether I can ask for myself. So thank you so much for this talk. I think it's in some ways so essential to our topic, which is precisely about the determination of the divine within a sort of a group situation, right, of consensus. What I'm wondering, I actually have two questions. One is the question of the singularity of the law. Does the situation of compound consensus that you mentioned imply somehow that the law is ultimately singular? That's why these two systems are somehow end up sort of interdependent. And then my second question is, how can you say something about the social historical generation of this set of thoughts, and how much is dependent on the sort of fact of the multiple juristic schools? Do you need the juristic schools first before you need to come up with some of this thinking and consensus?
Yeah, I think they're both great questions. Thank you, Dr. The first one, I don't think it's demonstrating the singularity of the law. What it's, for me at least, is demonstrating is that depending on the set of causes that you make relevant for your legal exercise, and they may be entirely wrong because there's a probability that the Abu Hanifa was wrong or the Shafi was wrong, depending on your absorption of those into your legal system through the proper exercise of legal tools and so on, what is generated through such exercise by a qualified person like Malik or the joint group of Shafi and Abu Hanifa, that system becomes God's law. Not God's law in the sense of that which is out there, right? The real one, the singular one, but God's law with respect to praxis, obligatory in that sense. And in that sense too, it's not relative, right? We're recognizing the coherence of the system is that which grants it its authority by virtue of consensus. They're indeed competing systems within it, competing in the sense that they're different, but not competing in terms of the claim of all groups that they are each of them coherent relative to themselves. But we don't know which one maps on exactly to God's law. So that's what I would say about the first question. The second one, the formation of consensus, is something, I mean, the historical aspects of it is something I myself obviously have not worked on, but other scholars have. And the great motivation seems to be to shore up an ever evolving system of legal effects in the early Islamic period. You know, with the departure of the Prophet of Islam, presumably there's no one exactly to answer the questions that are derived from the text, and the principle is invoked as a way to shore up the system, to produce some kind of coherence and continuity. I think that's a very important function of it as a theory, historically, because one of the main anxieties in the Islamic legal tradition is what happens when a particular generation has a consensus at one point and somebody disagrees after the fact, or what happens if a generation has produced consensus and they all pass away, in the next generation somebody disagrees. Will the consensus hold? The opinion of the, well, generally speaking, the demand that everyone from a generation must have passed away is never going to happen, right? People live in a range of ages. So that's a very good impediment to breaking consensus. Hypothetically, if that were to happen, there are meta theories that are set up to shore it up, right? So for example, the Zahiri, which is now a defunct school of Islamic law, would argue that in the absence of a new indicant, namely a new consensus or some other indicant of law, the old consensus would hold. So they require a positive, equally strong or stronger indicant whereby the legal effect, the new legal effect would be produced and the consensus would break. So the absence of an indicant is an indication of the continuity of the past. That helps you shore it up, because again, to produce a stronger indicant would mean having a completely new consensus, which probably would not materialize in society, or having a stronger indicant, such as from the sayings of the Prophet or the Quran or something. So those are some of the things I can say about it at first blush. Is that Manan? Thursday.
We are practical after this. Minority.
Thank you for the talk. My question is about actually this comparison, which you never made it possible. The nafs al-amr thing. They don't use it, do they?
That was the expression.
That's the expression.
That's what I was translating.
Oh, okay.
It's everywhere. That expression is everywhere.
I'm thinking in terms of, like, you know, as you said, the law is out there, and I personally like to think about it along the lines of the spectrum. Law in the singular is not out there. There's a spectrum out there. It says, I think you're saying the same thing, that these are probabilistic models, right? They are trying to emulate and grapple with the kind of reality, and we cannot, of course, ultimately make a judgment as to what that specifically is. No one really can. I'm thinking more in terms of what underlays it, which we're not talking about in terms of the kind of theological underpinning of this kind of position, right? So it seems to me that there is an idea, or at least an epistemological positivism to a certain extent, that to some extent, Burhan, or like human reasoning, to demonstrative human reasoning, somehow aligns very well with what the divine will is. It seems to me you have to grant that assumption in order for this entire process to go ahead. But thinking from the perspective of a very skeptical Ash'ari, right, who would then come about and say that, oh, well, not really, insofar as I cannot truly, ascribe, say, value to X. By that logic, I cannot truly ascribe that kind of one-to-one correspondence to even something demonstrably sound to equate with God's reason, right? I'm thinking if within that assumption, what happens to the system then? Because then it seems that all I can ultimately do is to have a very kind of strict reading, and of course, usul will not exist. But of course, usul do exist, and very many of the practitioners are themselves Ash'ari. So, am I imagining a kind of a contradiction here, or?
There's one point that you made that maybe I didn't understand it. I do want to backtrack to that before I answer the question. You said that there would be a demand that demonstrative human reasoning must correspond to the divine will. Are you talking about the legal tradition, or?
I'm not talking about legal. So, so someone who believes in
because I just want to set down that is not demanded by any part of the legal system, right? There is no demonstrative reasoning. So that would just not happen. They will not grant it. So if you're talking about something else, then we can.
Yeah, the Mali example is predicated on Burhan, right? Once you can show that there is the two premises have a Burhan behind them, right? That shows up that legal knowledge produced by it now is sound, right?
Oh, you're talking about the parts of the proof.
Yes.
Okay,
Right.
now I'm back.
Now,
Okay, sure.
For someone who affirms the akal fa'al, right? If there's an active intellect, right? For that person, right, to say that is perfectly fine because they have an entire cosmology, which kind of accounts for this entire thing, right? But for someone who would, again, from in this kind of skeptical kind of view, who would say that, oh no, the akal fa'al, these are imaginary things. Sure, I can navigate, I can travel across the Atlantic, but that's all about I can get out of it, right? For someone who has that position, right, what justification do they bring about by saying that, oh, this Burhan ultimately does kind of allow for this kind of upgrade?
So the Burhan, for those of you who know, is that it's demonstration, right? It's actually a translation of the posterior analytics of Aristotle, and that's often what it corresponds to. So it's the highest form of argumentation that you can offer, from necessity premises to necessary conclusions. Okay, so the proof that we gave was supposed to be a Burhan, or demonstration, the proof of upgrading, meaning from the probabilistic epistemological state of the jurist to the certainty of practice. The first one, I think, one of them we can grant, I think, right? It's an axiomatic claim that whatever comes from two necessary premises leads a conclusion that is known, that is epistemic, right? So I can leave that one aside, I hope. I can go to the problematic one, which is the premise that whatever is the opinion of Malik is a judgment of God. That is being upgraded on the basis of consensus. And consensus itself, and we didn't get into this, but you know this from Zaisol's work, is presented as a tool that has the same kind of demonstrative value as universally circulated reports, for example, or even the Quran. So the consensus of the community, for example, the idea is that the consensus on a matter is based on certain statements of the Prophet, such as that my community will never completely agree on an error. That particular report from the Prophet is supposed to have been circulated or raised to a certain point of certainty through other tools, such that it grants demonstrative authority to consensus. So this is the work that you remember Zaisel does, right? He shows that we need to establish consensus as capable of authorizing demonstration. It itself, for example, among other things, is based on a transmitted report. That report is actually a unit report, but it's upgraded through another method and so on and so forth, right? So that's how it's becoming a demonstration by virtue of the consensus, which is, social fact. Good for now.
I like to think about it.
Is there somebody online?
There is, but go first.
Yeah, sure. Thank you. Thank you very much for this. So I've been trying to think to what an extent the clear, because there are these internally consistent and therefore divinely approved legal systems that can exist side by side, and each of them can be utterly true relative to itself, right? You therefore then have different equally valid truths that could compete but don't have to compete, and that they can become compounded through consensus, right?
Yes.
Yes. And then that therefore then is the deliberative moment, in that obviously it all then kind of aims towards a divine law, which you can however never fully comprehend, right? So the exact same method of proof is also brought forth, and what I'm now talking about are the astronomical systems. For example, what's that? I have a German word in my head, which is not what I'm looking for. Trapezes or pentagrams or what have you, which you can see existing in nature, but that are also obviously in the most perfect form within a thought world, right? Where we can delineate their trigonometrical capabilities. That is the same argument that is used to delineate the nature of the Trinity in Christianity in the Christological argumentations, right? Okay. Because what we need to have is a consensus how we can have a Father and a Son who are equally eternal. Mm-hmm. When, according to Aristotle, of course, it is, essence doesn't permit of degree. So how can a God that is the first cause, right, be of the same essence as a Son who by definition must be cause? Sure, right? I mean, it's a pretty simple proposition, which you then nevertheless have to, resolve. And so means of resolving, therefore, then are similarly propositions that are internally consistent, right? One of them says, well, you can use the Aristotelian sense of a category, or else you can use a more Platonic influenced way of progression that will then allow you to come to that conclusion. And it all will depend on different definitions of what words mean, right? What kind of Father aspect are you then actually going for, right? Because you can have different ways in which you want to be thinking about the essence of sonship and the essence of fatherhood, etc. So therefore then you have in both instances very high levels of internally utterly rational and consistent systems, which must be brought into consensus, or else you cannot ever approximate the divine truth that you're trying to go for, right?
Right.
That's what this is.
Yeah, no, it's very similar. I didn't know that this mode of reasoning in Christological debates. So
not a lot of people do, because it's pretty abstract, right? But I mean, that's obviously what they're doing on very similar bases.
I didn't know that they deploy consensus at the end.
Well, you need to have the consensus, or else you can't determine what the Trinity is, right? And then that consensus is then reached through other ways, some of them legal, but ultimately, I mean, it has to be internally consistent, because we have to agree at some point, what Father, Son, and Spirit, why they are one. And if you can't reach that agreement, then you're not going to have divine truth.
And I think this
meaning, but of course, all on the premise that that the essential divinity remains unknowable, essentially, right, by human reason. So you can only always ever approximate.
Yeah, and one feature of Islamic law that I've noticed is that, of course, the law expands, right? There are new issues that emerge and so on. And what I've noticed is that where a proposition, let's say, is demanded by political, social contingency and the outcome as derived from certain existing causes that are accepted within a given consistent system would produce a conclusion that would offset some other given conclusions. What they end up doing is often they make them exceptions, not exceptions that we're going to accept it just for the sake of it because we want to, but they would say that, for example, a particular cause which we accept as part of the system from which the whole is unfolding is not operative here because there's a prohibitive cause, canceling it. So they bring out sort of external factors that would cancel a particular cause that would have had an effect in producing a legal effect that they don't want. But they establish that legal effect while keeping the system consistent by somehow blocking various causes.
Yeah.
So, I mean, these are, so I mean, what I've noticed in the elaboration of the law is, again, this effort to make sure that the whole does not collapse. And the fact that the system is complete as a whole, proceeding from a legally qualified jurist about whom and who's following rules. There's a consensus that's also sanctioned by God through this mechanism that we talked about from Zysov. I think that's what's producing the multiplicity of the law. But I think to think about Islamic law as a philosophy, an Islamic philosophy of law, I think this is neither a relative set of systems, nor is it the idea that one of them actually corresponds to the singular law of God. I think the main point here is that they are true by virtue of their given consistent selves. That's what obligates you to practice, right? If you know something, if you believe something is necessary by virtue of the set of propositions and claims and causes and syllogistic reasoning and so on, by consensus, that becomes obligatory for you through God. It becomes a judgment of God on you relative to you.
And that's a really interesting thing because, as I said, in those Trinitarian debates, you also need to reach a consensus, right? Eventually. And it's a very, very long drawn out process. And the second you reach a consensus on one particular aspect, then of course you have that domino chain of logical implications, which then forces you to reach consensus on the outcomes of, the prior consensus, if you see what I mean, right? Because they have, as you were saying a little bit with your vomiting and touching it, because each of them will have different, as it were, consequences.
Exactly. Yeah. And what was demonstrating is that if you join them, then you have a different system altogether.
That's exactly right. Yeah.
Yeah, sure.
Yeah. I have a question about, so the analogy that you made with the astronomical one. So I'm with you as far as the validity and the particularity of the legal system and the legal model is concerned, right? But when it comes to the question of the normative nature of law, and which is a question that one needs to address in the context of philosophy of law, I'm wondering, how does consensus hold over time? And if within particular contexts later on, so for example, when new cases are brought up, how can one hold on to consensus that have been achieved in upholding or deriving analogous cases or not precedents, because that won't work, but once consensus is achieved at a particular time, how does it hold over? How do you hold on to it? Its probative force. How does it survive? On what basis?
Right.
I'm asking this keeping in mind the fact that when we talk about astronomical models, they are not only valid but normative, given the fact that they are mathematical, geometrical, and also their predictive capacity has an important role to play in their functional ability. That's the word. But when we think about legal models, how does consensus that's achieved at one time, and given the fact that it has played such an important epistemological role, how does it survive? In the case of astronomical models, one can run that algorithm, so to speak, right, and sort of re-verify the mathematical sort of derivations. There's a discursive process that holds the model together, but if consensus is doing the heavy lifting epistemologically, how does it hold over time?
I mean, your basic question is how is consensus holding over time, right?
Yeah. and I'm framing it with the astronomy example because you
the astronomy example I can say from point of the philosophy of science is that there are systems and a consensus that is established in basic propositions that we're not willing to let go of. And it's only, certain cases that you have these revolutions, which, where you have to, normally what you have is, for example, Carl Hempel talks about this, right? So if you have a system that holds together consistently and gives you predictive capacity, and you run into an observation that undoes things for you, you have one of two choices. You either undo the system itself, or you introduce something into the system that will allow the consistency to hold. And that's a pretty arbitrary choice, right? Normally, in other words, you want the same kind of, conservatism in science. You end up having it the same way as you do it in law. I hope you get the point, right? So if you have a series of propositions that hold together, produce a whole wonderfully predictable, wonderful science at a predictive capacity, and then you observe, a phenomenon where you, let's say, shoot a photon that has a unit value of energy value of 2, and it comes out on the other side, somehow displaying the unit value of 3. You either hold on to the principle of conservation of energy, or you introduce some other particle or something. So normally that's how science seems to proceed as well. But that comment aside, the way consensus would hold is by using certain meta theories, and they're deeply concerned with the question that you're raising. It was actually, I think last week or 2 weeks ago, I remember that I gave a paper at George Mason on istishab. This is the idea of the presumption of continuity in Islamic law. And istishab, often again translated as a presumption of continuity, is defined in the sources as dalil man la dalila lahu. It is the indicate or proof of someone who has no proof. And the argument, Daniel is concerned, I thought. I'm very worried. The argument is that that if there is no indicant for change, then that which you hold to be true in the past, let's say, or that which you have established to be true, will continue to hold. You need a positive indicant to carry through. Let's say this is the past, right? There's an indicant, there's a ruling attached to it. If this indicant continues, of course, in the future along with it, let's say this is consensus, it continues with it, then the ruling will hold. What happens when hypothetically, this cause disappears? Their argument is that, well, it will still continue to hold unless you have a new indicant to change it. So that's a meta-theoretical position that they present in order to shore up the continuity of consensus. I mean, it's a very complicated theory. Hanafis, Mu'tazila, and so on, they all disagree and have different, very complicated arguments about it, which will be in a forthcoming article. I've done it, I'll share it with you. But that's how they try to argue for continuity. So they get yet another principle now, right? Is this how?
I have one question, which maybe we can end on from the Q&A. There was also another question in the chat, which I think is very similar to the question which was just asked. So this is from Jibril Delgado Trabal. Could Dr. Ahmed say something about Muhammad Khalid Masood's view that while the Quran and Sunnah are material sources of law, consensus is the real or normative source, that the law is socially constructed by the general body of scholars? And Masood is speaking from colonial and post-colonial periods.
Yeah, I'm afraid I don't have too much to say because I agree with this comment, and I think that's what I was in one way aiming to demonstrate. What I suppose I spent more of my time thinking about how this particular situation would allow us to think about what Islamic law is, and but not in disagreement from what we saw at least.
Shall we? Well, thank you.